Okay, this is People of the State of Michigan versus Mr. Rogers Jameson, docket number 20-864FH. And this is the time set for hearing on the defendant's motion to introduce alternative source of injury pursuant to MCL 750.420J. And Mr. Rogers Jameson is with us remotely with counsel Mr. Jackson and Ms. Allen for the people. And Mr. Jackson, you can go ahead.
Thank you, Your Honor. We're here for our scheduled rape shield motion. And admittedly, we don't necessarily believe that the conduct that we're about to present necessarily falls under the rape shield statute, but we can basically anticipate an objection as soon as any type of sexual conduct is mentioned from or by or with involving the complaining witness here and somebody other than the defendant. So basically, Your Honor, you've had a chance to read the brief. I know you don't have, I don't know if you read the entire preliminary exam transcript or have privy to the police reports, but the conduct that we are plan to have evidence about has to do with the complaining witness on the same day and time and place and everything with other people other than the defendant here. We believe that introduction of that evidence is very important to Mr. Rogers' defense, and that prohibiting such testimony or evidence would violate his rights under the Confrontation Clause of the Sixth Amendment. Under that clause, basically, Mr. Rogers has a right to face the prosecution witnesses and also the right to dispute witnesses' testimony against him. And in this case, the prospective testimony and or evidence is, again, going to be directly related to what happened that day. In fact, it's so related that when Mr. Rogers was interviewed by the police officer, he said that, and he named 3 other people, that they had some contact with the alleged victim here. He said sex, and he told that to the police during his interview when he was told that he was free to leave being investigated. Not only that, Your Honor, there's some evidence that's from the alleged victim herself in this matter that has to kind of do with this defense that Mr. Rogers has, as far as when she talked to the police the first time, Your Honor, in her statement in the police report to Detective Payne, and that's page 8 out of 16 in my packet. She basically said that she was alone smoking by herself. And then in her transcript, she says that, well, this other boy, Jaden, was there, defendant was there, and possibly other people that she doesn't remember. And I meant the police report when she told that to detective. So the complaining witness is one saying that no one else was there, but she's also saying at a different time that other people were there. And this is going to go directly to Mr. Rogers' defense when he testifies, if he testifies, and when other defense witnesses testify. But not only will it directly affect Mr. Rogers' right to his confrontation clause, it also is admissible otherwise because it's relevant and probative to the matter here. Here, there's, again, testimony that the complaining witness has either memory problems admitted in the police report and in the transcript and in her statement that she did use mind-altering materials, but she either has memory problems and is mistaken, or what she's alleging didn't happen. And either one of those when proven or disproven, would be very relevant and material and not overly prejudicial in this case. Also, Your Honor, the defense is not arguing that this alleged or this proposed testimony from defense will be used to harass or chastise. The rape shield statute is fairly clear that what's prohibited is efforts and attempts to unduly prejudice the alleged witness or to harass or chastise. But here, there's none of those things happening. This is not proposed testimony of another day or time or place. It is the exact apartment during the exact time and day that the complaining witness says something happened. There will be testimony and or evidence that shows something completely different. And for Mr. Rogers to possibly be precluded from that would be detrimental to his case in many ways. One, because if he were to take the stand, he already said things to the police officer. He already made a statement of what happened. And to even think about having to avoid saying those things or anything different would just be, I guess, maybe insurmountable for him. Also, Your Honor, there's, again, just pointing, and I know you don't have everything in front of you, but just going to the materiality and the probativeness here is important, because Your Honor has to not only consider whether the confrontation clause is violated on a case-by-case basis, but you have to kind of apply a balancing test on the rights of the victim and the defendant in each case. Here, it's Mr. Rogers who's facing a serious felony charge, whose entire life is, in the balance. Now, granted, we're not saying that the allegations aren't serious here, but the U.S. Constitution and our criminal justice system is supposed to kind of bend towards protecting the defendant's rights here. And here, the confrontation clause, and I believe it's, it might be in Your Honor's bench book as well, but there is a balancing test to apply. And here, the allegations are one thing that she said, but the testimony and the defense of Mr. Rogers is going to be something different. And it does have to do with sexual conduct and contact with people or in person other than Mr. Rogers that has to do with the victim. So the defense wanted to bring this motion today just to prevent at trial any delay or confusion, anticipating objections, but also reminding the court that there is definitely a confrontation clause issue here, and Mr. Rogers certainly needs to be able to put on his defense of what he says happened based on how he perceived it on that day, at that time, at that place, involving parties already mentioned in the police report and spoken about and questioned about during the investigation. It's disputed cumulative facts that is in question. I think it would be up to the trier of fact to determine what happened and who is, and whether Mr. Rogers is guilty or not.
All right, thank you. Ms. Allen?
Thank you, Your Honor. And I would say to Mr. Jackson, I appreciate doing this in advance like we're supposed to, rather than it coming up at trial where this evidence is trying to be admitted while the victim's on the stand. So I do appreciate that. And we did submit to the court the preliminary examination transcript. I know the court's supposed to get a copy, but I did send that over, and it has not changed our response. Initially, there's a difference between these people being present and the defendant trying to establish an identity defense rather than stating this victim had sexual relations with 3 other people. The defendant wants to bring in this evidence that the victim allegedly had sexual relations with 3 other men to show an alternative source of her injury pursuant to MCL 750.520J1. And in his motion, the defendant says the alleged rape itself is an injury. And I believe that's an incorrect interpretation of the statute and the case law. As this court's well aware of the statute, it says evidence of the specific instances of the victim's sexual conduct, opinion evidence of the victim's sexual conduct, and reputation evidence of the victim's sexual conduct shall not be admitted. That's the first section. And only to the extent the judge finds the following proposed evidence is material to a fact at issue, and it's an inflammatory or prejudicial nature, does not outweigh its probative value. A, evidence of the victim's past sexual conduct with the actor, the defendant in this case, or evidence of specific instances of sexual activity showing the source or origin of semen, pregnancy, or disease. So here, as we pointed to in People versus Shaw, which I know this court is familiar with as it came out of this court, the Michigan Court of Appeals says, if we're going to use this evidence to show the origin of a physical condition, when you can use that when evidence of that condition is offered by the prosecution to prove one of the elements of the crime charged. At this time, we have no physical evidence of an injury or plan to bring that evidence in. Should that change, I think this motion could be rebrought. But at this time, per the statute, this evidence, the purpose is to be inflammatory and prejudicial in nature. And it's actually designed for the reasons excluded under the rape shield motion. It cannot be brought in unless there's an exception or a reason to be, and there hasn't been one presented here. The defendant still can present an identity defense well beyond having to admit any evidence of what the victim may or may not have done with other individuals. He's not precluded from that defense. Identity absolutely could be a defense. But if there's no injury or no evidence of an injury that the people are going to bring in, he cannot bring in this other evidence to rebut that theory if the theory has not been presented. We'd ask the court to deny the motion. Thank you.
Thank you. Yes, the rape shield statute protects against this type of evidence unless if it becomes relevant for a valid purpose. One of those could be to show that if there's a physical injury, it actually came from someone else, and then it's fair game. Assuming that all the requirements are met under the rape shield statute, to talk about the victim's activities with someone else. But that is not the case here. There is no physical evidence for the complaining witness. And if there's no physical injury of the complaining witness, then there can't be an alternate source of the injury under the Rape Shield Act. If the defense theory here is that every sexual assault constitutes a physical injury, but if that were the case, it would completely annihilate the Rape Shield statute, and it would make complaining witnesses' sexual activity with other people always admissible, because there would always be a physical injury and it would always come in under the statute, and that's just simply not the case. So there is no physical injury here that's being alleged, and there is no alternate source of injury that can come in under the Rape Shield Act or statute. I don't think that it denies the defendant a defense, because defense has articulated very well today the potential ways that this could be approached. Did the complaining witness make conflicting statements, and her credibility could be impeached as to whether there was other people there or whether there were not other people there? Did it just not happen? Did she make it up? Did she imagine it? I'm not endorsing these things. I'm just saying that those are all valid defenses that can be pursued without running afoul of the Rape Shield statute. So I don't think it deprives the defendant of a defense to say that this did not happen and to attack the credibility of the complaining witness. But this evidence that they're seeking does not come in under the Rape Shield law. So the motion is denied.
Thank you, Your Honor. Question just is, do you make any opinion on possible confrontation clause, or would that be a motion that might happen in trial if it comes up?
There was nothing in your brief that I recall about a confrontation clause argument. I think I just summarized the argument that you made, so my ruling is what it is.
I'm sorry, Your Honor, but there is in my brief confirmation clause.
Well, my ruling is what it is. It can't come in. Okay, that will conclude our hearing in this matter. And that is,
I'm sorry, Your Honor, and I do respect your ruling, but I guess I would just to preserve the record, object. And I don't know how relevant it may become, but right under the first word in the argument section is the confrontation clause guarantees, and it goes on from there.
well, Mr. Jackson, everything is preserved because you filed a brief and a motion, and it's part of the record and it's in the court file. So that is well preserved.
Thank you.
Thank you.